Okay, welcome to this session, very interesting session that let me tell you, for maybe some of you are quite APPI members, but there are some young participants that might be quite regular assistants. And let me tell you that for more than 120 years, WIPO and AIPPI have been straightening the bridge of understanding on the advanced study of intellectual property at the international level. This has been a very educational growing process. And today we have jointly organized 2 webinars in relation to a complex topic related to traditional knowledge, genetic resources, and traditional cultural expressions. Today, the webinar, Why We Are Here, is about IP protection on TCEs, or traditional cultural expressions. And we have an expert, a guest speaker from WIPO, Daphne Zographos Johnson, that she's a senior legal officer of WIPO. But also please put in your agenda and your calendar, we will have a second one, jointly organized by WIPO and AIPPI on June 7 about genetic resources related to traditional knowledge. But this has been possible by the support of the Traditional Knowledge Division of WIPO. His director, Wen Welland, he joined us. We will heavily appreciate and thanks all his flexibility, enthusiasm, and interest on this event, but also by the support of the AIPPI, the Bureau of AIPPI, represented on this session by Ralph Knack, who will address also our welcome remarks. But before I pass the floor to them, I should mention that these 2 events are possible to be conducted due to the WIPO teamwork, supported, guided by Begoña Venero. She was fantastic. And from the AIPPI subgroup, Traditional Cultural Expressions, guided by Karen Abraham and Maria Pilar Troncoso of the AIPPI committee. Thanks, Begoña. Thanks, Karen. Thanks, Pilar. But also thanks to Michelle and Cinzia, who we cannot see them, but they are behind this camera and are the person who makes these things happen. Thanks to all of you who have taken your time, your agendas, and to be excited for this event. Wen, thanks again, and the microphone is yours.
Thank you, Martin, very much, and good morning, good afternoon, good evening to all of you who have joined us here. I acknowledge the presence of Ralph Knack, AIPPI Second Deputy Reporter General, and I know Ralph will take the floor after me. And as Martin has said, I'd like to thank the Bureau of the AIPPI for the extraordinary work in organizing this webinar. Martin, of course, you have been the prime mover behind this, and thank you for your enthusiasm and your tremendous efforts to bring this event to life. And also, as you mentioned, Karen Abraham and Maria del Pilar Troncoso and everybody else behind the scenes and in front of the scenes. It's a tremendous pleasure for WIPO to co-host this webinar on how to protect and promote traditional cultural expressions. I salute the AIPPI and especially the standing committee that Martin chairs for initiating the idea of having such an event. These webinars reach your important membership, comprising individuals who are key actors and stakeholders in the IP ecosystem. And I'm sure and I hope that through these webinars, your members will become not only more informed, but also more engaged and more active on these issues, which ask deep and profound questions about the kind of IP system that we want to have. What should it protect? Why? And for whose benefit? Indeed, the protection of cultural expressions is integral to the design of the future of IP. Your greater engagement and action will help us at WIPO to provide our services in this area, which includes facilitating the work of the IGC, And this webinar is very well timed because it sort of rolls the pitch. The next session of the IGC takes place at the end of August after a long break because of COVID. And the support we provide to Indigenous peoples to make more strategic and effective use of IP tools in their businesses. And my colleague, Daphne Zografos-Johnson, will be speaking to these issues and these services shortly. We also very much look forward to the second webinar in the series planned for June the 7th. Beyond the webinars, we'd like to deepen our partnership with the AIPPI on these issues. Tremendous practical legal experience and expertise and network capital reside within the AIPPI, both of which are desperately needed by Indigenous peoples as they try to navigate their way through the IP system and make smart use of it. We have recently signed an MOU with Inter, which has agreed to provide pro bono legal services to our beneficiaries. And we look forward to discussing further opportunities to work closely with the AIPPI moving forward. Finally, I thank Daphne in advance for what will no doubt be, as usual, an excellent presentation, and Begonia Venero, also my colleague who has been our principal liaison with the AIPPI in organizing these webinars. With these few words, I thank you again, AIPPI, welcome all of the participants, and hand the floor back to Ralph. Thank you.
Thank you, Wendt. My name is Ralph Knack. I'm the second Deputy Reporter General of AIPPI. I greet you on behalf of the Bureau. Let me first thank WIPO, in particular, Mr. Wendland, Ms. Johnson, for joining us today. We are extremely honored that you agreed to co-host this seminar and to give the presentation today. The topic we are going to cover here in this seminar is actually a very important one. The first reason is it has been a little bit silent on that topic. And AIPPI realized that this topic is a field of intellectual property law where a tremendous improvement can be still made compared, for example, to patent law or to trademark law, which is very developed, very established. But in today's area of today's topic, there are a lot of issues which went briefly addressed, where people might think, oh, how are we going to do that? How can we do it in a better way? And how can we harmonize the way how we do it across the various countries? These are issues which AIPPI is very much interested in, and where we want to contribute to the improvement and the harmonization of the law. And therefore, we are extremely thankful for the partnership with WIPO, but we are, of course, also extremely grateful for having Martin Miekhaus as the chair of our Standing Committee on IP and Genetic Resources, Traditional Cultural Expression, and Traditional Knowledge. Martin has done an extraordinary job of pushing this topic ahead, bringing it to the attention of the broader membership, and last but not least, organizing this webinar. So from the perspective of the Bureau of AIPPI, we are extremely pleased that we are meeting today and that we are going to listen to Daphne's excellent presentation. And we are all very excited to learn. Me personally, being a patent litigator, I must say I must learn very hard. And I guess many of within the membership of AIPPI have the same desire to learn more about this very important topic. Thank you. Over to you, Martin.
Thank you, Wen. Thank you, Ralph, for your kind words. No doubt that with listening to you, it's quite encouraging to continue pushing this topic in this way. And then we have the best part of this webinar. We have Daphne. Let me tell you something that you may have heard probably about the Delors report of 2000, in which he speaks about the tensions among societies on this 21st century. Among others, he pointed out the tension between tradition versus modernity and the challenge around it. And I believe under this framework, in this perspective, the traditional cultural expressions are in the middle. And it's no doubt that this traditional cultural expression, the TCEs, has attracted increasing attention not only for governments, cultural institutions, indigenous people, of course, but also local community policymakers, industry, and also to the IP practitioners. No doubt that's the growing recognition about the cultural and economic value, of the TCE, particularly associated with the TK or traditional knowledge. Experts have been discussing this, how to the IP can protect the TCEs at the international level. And we are in the best hands to listen about the perspective of this issue. We are, believe me, quite fortunate to have Daphne Sorafa-Johnson with us. Let me tell you that she's a senior legal officer in the Traditional Knowledge Division of WIPO. She has only 20 years of experience, researching and working in the IP, traditional knowledge, and traditional cultural experience. Prior to joining WIPO, she was a lecturer on IP law at the University of Reading in the UK and a visiting lecturer in trademark law at King's College London and Queen Mary University of London. She holds an LLM in IP law from University College London and a PhD from Queen Mary. Her thesis focused on the use of existing intellectual property rights to protect traditional cultural expressions, a main topic we are going to listen from her. She's also the head tutor of WIPO advanced course on intellectual property, traditional knowledge, and traditional cultural experience that, by the way, I highly recommend it. It's quite interesting and fruitful and a lot of material. I myself have taken and has very good experience. But also Daphne is passionate about IP and sustainable development. Quite interesting issue. She has traveled widely both in her work and free time, and she's always curious to discover new countries and cultures. And with this perspective, I believe you will be delighted hearing from her about this topic. On the rules and methodology of APPI, we will listen to Daphne, and it will be open a section of question and answer. Please take advantage and the opportunity to ask Daphne. She is an expert on this field and will answer a lot of questions, because don't remember, as Wayne said, we will have a second webinar with WIPO about genetic resources, but we will have a second webinar on TCEs in July 29, and this will be the basement of this discussion. Daphne, welcome, thanks again, welcome to APPI. Thank you, the floor is yours.
So many thanks, dear Martin, for your kind words and your introduction. And hello, everyone. It's a real pleasure to be with all of you. Well, this morning or afternoon or evening, depending on where you're all based, and to discuss this exciting topic. I mean, obviously for me, it's the most interesting topic, but I hope that you will also take pleasure in finding out about the relationship between intellectual property and traditional cultural expressions. For those of you who haven't looked into these issues so much, and also for those of you who come already very well informed, I'm sure. So I'm going to start sharing my PowerPoint. I'm going to use a PowerPoint, and we're going to take for that about half an hour at the most, because it would be good to have enough time to have a good discussion with all of you, and I'm already looking forward to the discussion part as well. And so today we're talking about intellectual property and traditional cultural expressions, or in short, sometimes we call them TCEs. So what we will do in a nutshell, I'm going to tell you a little bit about what are TCEs and what is also traditional knowledge, which is the other side of the coin of traditional cultural expressions. I'm going to tell you about their relationship with intellectual property, and then we're going to discuss a little bit the legal issues that come up when we're thinking about protecting traditional cultural expressions with intellectual property rights. We're going to see what are some of the options, both for protecting them, but also promoting them with intellectual property tools. And then I'll tell you a little bit about WIPO's work and share some tools and resources. So that's the program for the next half hour. So starting then, what are traditional cultural expressions? So, and here I can only give you a description, let's say, because us lawyers, we like to have specific definitions about things, but at least at the international level, there's not an agreed definition at the moment as to what traditional cultural expressions are. So we work with descriptions. So TCEs, in short, can be described as the forms in which traditional knowledge and culture are expressed. They can be both tangible and intangible. Like, for example, a traditional painting would be tangible, but a traditional tale that is not recorded in a material form is intangible. And they can really be many, many things. So they can be songs, they can be paintings, performances, they can be words, symbols, logos, designs, motifs, works of architecture. So really, it's the lists and the types of cultural expressions are as varied as the many and beautiful indigenous communities and local communities that hold them. And here I would like to say a few things also about traditional knowledge. So sometimes people will talk about traditional knowledge in a general term as encompassing traditional cultural expressions. So for us IP lawyers, it's sometimes useful to make the distinction. So for many indigenous peoples and local communities, they don't really distinguish between traditional knowledge and traditional cultural expressions. It's all part of the same thing. But traditional cultural expressions are the expressions of the culture, of the traditional knowledge. And for us IP lawyers, they can be associated more easily with works of copyright, perhaps. And traditional knowledge as such, it can be described as the knowledge which results from an intellectual activity in a traditional context. And it would include know-how, skills, innovations, practices, learnings, and so on. It's not limited to a specific field. So here again, the areas where you'd find traditional knowledge are quite varied. You can have traditional medical knowledge, for example, traditional knowledge about how to use genetic resources, traditional knowledge about climate change, and so on. But it has this a little bit more technical aspect to it, if I may say so. So in this presentation, I know we're focusing more on traditional cultural expressions, but it's fair to say that a lot of the issues that apply to TCEs, traditional cultural expressions, also apply to TK, so I will be referring to both. I think some of the key elements, the key points in these discussions are to be really aware of what are some of the characteristics of TK and TCEs. And these will be very important when it comes to the discussion of how do we then protect TK and TCEs with IP rights. So some of these characteristics include the following. So they are usually handed down from generation to generation within a community. That means that there is an element of time when we talk about TK and TCEs. And that being said, however, it does not mean that they're stuck in time, because very much they're still evolving, developing, and being recreated within a community. But there is this element of time, and very often you'll find that some cultural expression, perhaps some style, or underlying ways of performing traditional cultural expressions, or creating things based on those traditional cultural expressions, have been around for quite some time. And then also, in a lot of the cases, they are made by unknown authors. So they're regarded as belonging to a community. And even here, the word belonging is not actually absolutely right, because it's not belonging in the Western IP sense of the term, if I may say, but it's more that communities see themselves as being the custodians of the TK and the TCEs, and they're the custodians for the next generations. They're held, let's say, in a community environment. And when we do not know who the authors are, and as IP lawyers, you know, you're already one step ahead of me, I'm sure, it's very hard to vest rights and to give rights to someone, IP rights to someone, when you don't know who that person is, you don't know who the author is. So generally speaking, traditional knowledge and traditional cultural expressions are creations and innovations of the human mind, so they are intellectual property. But can they be protected by intellectual property rights? That's the question. And because of the fact they are of the fact that they are traditional knowledge, they are traditional cultural expressions, we have this element of time, we have this element of a community. We don't know who the author is, they've been around for a long time, and so on. Sometimes they cannot be fully protected by the existing IP system, because if we want to give copyright to a creator for a work, we need to know who that person is. If we are going to patent an invention, it needs to be new and inventive, and traditional knowledge sometimes has been around also for a long time. It may be well documented, and it may not have be able to fulfill those criteria of protection for patents. And then if you want to protect a symbol by with a trademark, you need to have as an objective to use it in the course of trade. And very often some forms of cultural expressions may be secret or sacred, and you don't want to use them in the course of trade. So protecting a sacred symbol with a trademark would not be possible as well. So there's a little bit of mismatch between these forms of intellectual property that are TK and TCEs and the existing IP system, which means that sometimes the existing IP system, actually quite often, is not fully appropriate, hasn't been conceived with protecting TK and TCEs as an underlying policy objective. So we see that clearly there are a number of gaps in the existing IP system that preclude the IP system from adequately protecting traditional knowledge and traditional cultural expressions. Now, what are then the options? So what do we do from here if we want to protect TK and TCEs with intellectual property? So we have a number of options. So one option is to say, well, the existing IP system is not perfect, far from it, to protect TK and TCEs, but you know, it's still possible to use it sometimes to protect and promote traditional cultural expressions. And in the second part of this presentation, I'll give you some examples of that. Another way, and what some countries have done, is that they have adapted their existing intellectual property laws to better protect TK and TCEs. So for example, in New Zealand, they have amended their trademark system And now it provides that when someone applies to register a trademark that contains Maori words or imagery, a specific committee would examine that trademark application to determine whether or not it would be considered offensive to the Maori people. So that's an example of going one step further and adapting an existing IP system, here trademark law, to better protect TK and TCEs. But here again, the protection will be better, but it will not be optimal, because it is still possible for third parties to register trademarks that contain Maori words or imagery when they're not offensive, for example. So there's no right for the community to say no in that situation. And then the third step is to create a new sui generis system of protection. That means a new law, a new intellectual property law that would specifically protect traditional knowledge and traditional culture expressions. And that's a number of countries have chosen to create a new law like that. And some regions at the regional level, groups of states are considering it as well. And within WIPO, our member states are also negotiating the terms of an instrument in that direction. So I'm going to start by telling you a little bit about sui generis systems of protection, and then we will go to discussing what can be done with the existing conventional IP system as well. All right, so what would it mean to have a sui generis protection of TK and TCEs? It means that TK and TCEs would be recognized as a form of intellectual property alongside patents, trademarks, copyright, and so on. And then protection would be provided by a special system that is based on the kinds of measures, principles, and values that underlie the existing intellectual property system. So that means that a number beneficiaries of the protection would be granted a number of property rights, like, for example, exclusive rights, perhaps also non-property rights, like moral rights, but then there would be exceptions and limitations, like the other types of IP rights, where you have like a number of rights and then the exceptions, and that's the balance in the IP system. So a sui generis system, sui generis laws to protect TK and TCEs would also operate according to the same model. Now, at the international level, in WIPO, there is an intergovernmental committee on intellectual property and genetic resources, traditional knowledge, and folklore. And in short, we call it the IGC. That was created in 2000. And basically, it's a forum where negotiations take place for an international legal instrument on traditional knowledge, traditional cultural expressions, and genetic resources. Now, there are a lot of participants in these negotiations, obviously WIPO member states, but also indigenous peoples and local communities are represented, as well as business, civil society, and a number of NGOs as well. And you can see on the slides pictures of the sessions of that committee. Now, the IGC is developing a sui generis system of protection for TK and TCEs at the international level. Like I said before, it's doing that using IP principles, values, and systems. Now, at the moment, there are 3 negotiating texts. So there is one text, which is draft articles on the protection of traditional knowledge, draft articles on the protection of traditional cultural expressions, and then a consolidated document relating to intellectual property and genetic resources. So I'm not going to show you any of the articles at this stage, but what I would like to do is to briefly mention some of the key questions that member states of WIPO are discussing in the context of these negotiations. And for any countries at the national level who would also like to, at the national level, engage in consultations or policy formulation for law on IP and TK or TCEs, these are also the type of questions that they would need to consider in one form or the other. So briefly to take you through the questions, again, without showing you any actual article, it's very important first to know what would be the objectives of protection of this kind of law or this kind of instrument. And this is really key. Is it to prevent misappropriation of traditional knowledge, traditional cultural expressions? Is it also preservation? Is it that they would like, to get some benefit sharing? What are really the objectives of protection? And once the objectives of protection are identified, these then drives the rest of the provisions of the instrument or the law. What to protect, so subject matter of protection. So that would be possibly a description or a list of the types of cultural expressions to be protected. Who should benefit? So obviously indigenous peoples and local communities should be included in the beneficiaries, but should also countries, states be able to benefit? That's a question. The scope of protection is next, and that's really the key provision of any instrument on the protection of TK or TCEs. It would include any exclusive rights, or should there be exclusive rights for the beneficiaries of protection? Should there be any moral rights? And now the tendency in the international negotiations, at least, is to say that there should be what we call a tiered approach to protection, or a differentiated approach to protection, by which we would consider that not all types of traditional cultural expressions should get the same level of protection, but perhaps secret or sacred traditional cultural expressions should get the higher level of protection. That could be the rights for the beneficiaries, so the indigenous peoples and local communities, to say, no, you're not allowed to use, or you really need to ask for permission, and we have the right to say no, in which case third party would not be able to use the cultural expressions. And then for other types of traditional cultural expressions that are well documented, well known, then it would be perhaps more of a moral type of right, perhaps a paternity type of right, or integrity. So this is one of the tendencies which is interesting to know about, perhaps. And then exceptions and limitations. Other key questions would be, how long should the rights be granted for? Should there be formalities? Would you have to register a TCE in order for it to be protected? Sanctions and penalties, obviously, and then other questions such as should the rights be retrospective, and how would foreign right holders be treated? So these are some of the key questions in the negotiations. And if you want to find out more about, I would invite you to look at the draft articles. They are available on our website, and more than happy to provide more information on these and on other questions as well. Now, let's move a step back then. Now that we've heard a little bit about sui generis laws. And as I said, it's an ongoing discussion in negotiation in the context of the WIPO-IGC. And some countries may have moved forward already. They may be in the process of adopting their own sui generis law. They may already have done so, but not all countries would. And we need to see then there are existing IP rights, and they're not perfect, but they can be useful both to protect and to promote traditional cultural expression. So I'm going to say a few things about that now, giving you some examples. So obviously, when we talk about cultural expressions, we talk about various types of works that could also fall in the context of copyright. So as you all know, in copyright, copyright, in order to be protected by copyright, works need to fulfill a number of criteria of protection. And with traditional cultural expressions, we will have some limitations here, because copyright, in order to be protected by copyright, works need to be original, and it's not necessarily always the case with traditional cultural expressions. We need to know who the author is, which again, as I said before, is not always the case. And the term of protection is limited, and indigenous peoples and local communities would like an unlimited term of protection. And then you need to fix works in a material form for them to get protection, which is not always the case as well. However, for contemporary traditional cultural expressions, it may be obviously possible for them to get copyright protection. So there won't be a protection for a specific style or idea with copyright. So if I take the example of the Aboriginal dot style painting, the style as such of painting in that way cannot be protected by copyright, but contemporary works by Aboriginal people using that technique would be protected by copyright when we know who the author is. And here I put like an example of that lady, Jenny, who paints those beautiful paintings, and obviously we know who she is, and they're original, they're not a copy from another previous cultural expression, so she can get copyright protection. But there are all the gaps that I mentioned before, which mean that not all traditional cultural expressions, even though they may fall within the category of a work, they may be artistic and so on, but they won't all be able to be protected. Now, trademarks is a great tool because trademarks can be used both to protect, prevent third-party uses, and promote traditional cultural expressions. As you all know, there are mechanisms within trademark registration systems that would prevent the registration as trademarks of offensive trademarks and deceptive trademarks. So something which could be offensive to an indigenous peoples or local community can be prevented, won't get registration. And also something which is deceptive, which can give a connotation of an association with indigenous peoples and local communities when it's not actually the case, and where this would be quite an important purchasing factor for the consumer. That would be deceptive, and then they won't get protection as well. And trademarks may be used obviously as a distinctive tool and as a very valuable and strong marketing tool for communities. And here I want to give you the example of a case which comes from the US, which is Urban Outfitters and the Navajo. So the Navajo is a community in the US. They're quite large, they're quite well organized, and they've been very clever because they registered their name, the name of the community, Navajo, as a trademark with respect to quite a large range of goods and services. They did that obviously so that they're able themselves to sell and promote their goods and services using that name. But in doing so, they were also able to prevent a big retailer called Urban Outfitters from selling products using that name. So Urban Outfitters, at some point, they had a range of clothing and accessories, including alcohol, flasks, and underwear, actually, that they were marketing using the word Navajo. And you can imagine how that could be offensive to the community. And because they had themselves registered their name as a trademark, they were able to prevent that. So there are a number of cases. If you're interested in reading them, I'm happy to provide the references. In the end, urban outfitters and Navajos settled and agreed to collaborate on a range of accessories, I think it was. So it was a good outcome in a way for the community. But there are so many examples, and I think in your next webinar on this topic, you will look more closely at the topic of cultural appropriation, and this is really a big topic right now. You see it in the newspapers of very well-known companies, brand owners being put in the spotlight because they have used either names or designs or characteristic features and symbols of indigenous or local communities. So as all of you, many of you, I imagine, would be advising these brand owners, this would be a topic of interest to you. Just to say a few words on that, because it's so topical right now. It's important to raise awareness on these issues, because quite often, not always, but very often, the brand owners would not really be aware that they're doing something wrong, and that you know, elements of cultures that have this ethnic feel and ethnic trend, obviously that sells quite well, and appropriating or borrowing from cultures would be a bad thing. But actually sometimes it can be quite offensive to indigenous peoples and local communities, and also backfire on those brands through negative publicity in the media. Anyway, so the Maasai are one community whose name and some of their symbols have really been appropriated, used, and borrowed by a number of companies all over the world. And that was done without authorization, without benefit sharing. And recently, they have embarked on an initiative to reclaim the Maasai brand. So they used some IP lawyers working with them to negotiate with these companies, with these brands, to transfer those trademarks back to them, which that then they can license to the companies, and in that way get income through licensing, which they can use for community projects. So it's quite a good story. Now, because of the fact that there is this communal element with traditional cultural expressions, so they are held by communities. So obviously, some types of IP rights would be particularly relevant for their promotion. So these are collective marks, certification marks, and geographical indications, because you don't necessarily need to have like one owner. They can be used by many members of the community, and for indigenous peoples and local communities, they can also share the costs quite often. So increasingly, indigenous peoples and local communities are becoming aware and better are using these types of distinctive tools that are collective marks, certification marks, and GIs. There are examples, and here is one from Latin America, with the collective mark being registered by a cooperative of potato producers in the Andean region of Peru. And it's a great tool because, as I said, they can all use that collective mark, and they together build, are able to together join forces to educate consumers as to the qualities of the products marketed under the mark, and better distinguish them in the marketplace. So I'm going to not take too much time on this so that we can have a bit of discussion, but just to say that if you're working with communities and advising them, obviously the key element is to make a strategic choice as to which is the best IP tool. When we're talking about distinctive tools, we have the array of trademarks, collective mark, certification mark, GIs, and which is the most appropriate in a given situation. And then, so we have designs, and here I had an example that comes from Kyrgyzstan, which where in Kyrgyzstan, they have a lot of nomadic communities. And here they were very well advised, I would say, by some very clever IP practitioner, I'm sure, because they registered the design actually for a yurt that you can build. So you buy a little kit and then you build the yurt. So it's a registered design. It's also a registered trademark. And they have a great also clip and the marketing that goes with it. So, and a very nice slogan, which is Think Nomad. So they were very well advised. Now, just want to say a few words on collaborations before finishing. Whether you're advising Indigenous peoples and local communities or brand owners, I think increasingly there are opportunities for collaboration between communities and companies or third parties. And we always try to raise awareness to the fact that it's important to keep tradition-based innovations confidential as much as needed. And then have some key questions that communities should keep in mind when they are entering into negotiations with third parties and collaborations. And these are, for example, thinking ahead as to what kind of outputs could result from the collaboration, what IP rights could result, who will apply for the IP rights, who will own them, and how would the benefits be shared, to name only a few. Now, so as Van mentioned in the beginning, in WIPO, we facilitate normative work at the international level with the IGC, but we also do a lot of practical capacity building work. We have an Indigenous entrepreneurship program, and in the context of that program, we have that partnership with INTA that then discuss, whereby we can we do some matchmaking between Indigenous communities who have an IP business project and lawyers who can help them pro bono, but also in other areas, for example, documentation of traditional knowledge, cultural expressions, and other very interesting areas that I'm not going to go into the detail now. So if you're interested in further reading, I would be very happy to direct you to some reading on these topics. And we also have a newsletter that I invite you to sign up to for news and updates. So with that, I could be speaking for a long time because I'm very passionate about this subject, but I would be even more interested and keen to discuss with you all. So I'm going to stop sharing my PowerPoint now, and I really look forward to engaging with you and discussing.
Thank you, Daphne, so much. As you might agree with me, we're lucky to have Daphne and have the way she expressed very clear about this complex, very complex topic. Seems to be easy, but she puts it in an easy manner. I have so many questions. I don't know how severe is the time, but the first one is because I have received a lot of questions if we are going to be able to have your slides available.
Sure.
And another question, I have one that says from Manuel Guerra, what is the economic value of the TCE? How you can evaluate the economic value, sorry, of the TCE?
Sure. Do you want me to reply to that now?
Well, let me raise another one. We have somebody from India, and Jansen. I would like to know, is it possible to keep traditional knowledge secret, like a special mode of weaving, printing of fabrics to a particular source and yet claim exclusive IP right thereon? And if so, how that is feasible, or if so, does it conflict between patent law, disclosure-based rights, and secret traditional knowledge-based IP rights? Many thanks. Let me give you another one. Lars Brams, how will Indigenous people enforce their IP rights? Are there institutions to enforce rights on their behalf? Another one for Fabrizio Modica from Paraguay. How is cultural appropriation regulated and defined? And Maria Fernanda Gonzalez, tell us, would you be so kind to tell us which countries have a sui generis protection to date, if any? And Daniel Lim has, I think, a question and probably a comment and a question. In relation to the suggestion of trademark registration and the Navajo example, trademarks had to be used as a trademark. However, that concept of use of a trademark is expressed under local law, which can differ or risk being invalidated for non-use. Can you give some examples, or have you seen Indigenous groups make official trademark use of their trademarks in order to maintain their valid status and derive commercial value therefrom? And he continued, have you seen instances where issues have arisen as to whether trademark use has been by the relevant registered owner, which is likely to be a collective rather than a given individual or corporate legal entity, or has constituted use as a trademark for the purpose of the local trademark law? I have another one, is of Elena Castillo. Is positive or defensive protection possible in connection with TCEs? And Ibrahim Razak, thank you for your presentation. In an hypothetical situation, how do we settle a dispute between two indigenous tribes that claim ownership of a particular TCE? Well, we will need like 2 days for answer all these questions because Michelle is very strict with the time, but Daphne, welcome again.
Thank you. Thank you so much, Martin. And so how much time do we have?
Like 7 minutes. I don't know if Michelle could be able, so kind to extend it, but at the moment, 7 minutes, yes.
Okay, no problem. And thank you so much for all these very good questions and some difficult ones, actually. So yeah, I'm going to try and answer, give elements of the answer to some of these questions, and perhaps some of the easy ones first, on which countries have sui generis instruments. Actually, I don't know which region or specific countries you'd be interested in, but if you check on our website, so WIPO website, on the traditional knowledge division pages, we have a database where you can search by country and to find any protection, whether they have adapted existing IP laws, they have something in a specific article, or a sui generis law, and it's really like searchable and in quite detail, actually, depending on what you're looking for. So I would invite you to have a look at that. Now, so there was a question about positive and defensive protection of cultural expressions with intellectual property, and indeed, intellectual property tools can be useful for both. So in a defensive way, and I think perhaps it's, yeah, you could register an IP right, as you know, to make sure that you can prevent third parties from using it. And that's the existing IP rights. Obviously, the downside is that you need to have as an objective to use them in good faith. And the trademark example of the questions about trademark use, which I think are very good questions, also are linked to that, because if you register something just because you don't want someone else to be using it, then are you going to be able, should you be doing it in the first place, and will you be able to keep that trademark registration? It is a different question. But yes, you can use IP tools both for defensive protection, so preventing other people from either using your cultural expressions or registering IP rights themselves on those cultural expressions, and in a positive way, of course, by using all the IP tools that are existing to promote tradition-based creations and innovations. So on the trademark use, I have to say that most of the examples that I have in mind of communities registering their signs as trademarks, whether they are words, logos, or symbols, were actually registered with the objective of actually using it in the course of trade. So in a trademark sense, and with the in a normal trademark, with normal trademark objectives, I would say. So there are a lot of examples of that. And I'm not sure I'm answering your question, but I hope I am. There was a question about the economic value of traditional cultural expressions, and that obviously is a very difficult question. It will depend on many factors, and I'm not sure I can give a very good answer to that, because it would depend on the specific types of cultural expression, the country, the region, the situation. But to come back to the Maasai example that I gave in the presentation, because I was reading something about it just this morning, actually, and not figures I would have verified by any means, but the newspaper article I was reading was saying that overall, over the years, the valuation of the Maasai brand was around $10 million, with all the use that has been done by all the companies and third parties that have been using either the name or some symbols or imagery of Maasai communities. So again, it would be, I haven't verified the figures, but this is something that I read, and it would depend on each situation and each community as well. But I think that we can say with confidence, when we see the use that is being made of the various symbols of indigenous communities by various types of industries, that there is enormous value in them, in those traditional cultural expressions. So as far as secret traditional cultural expressions are concerned, well, obviously the best way to protect them is to keep them secret. So elements, elements such as like a breach of confidence laws and these kinds of mechanisms would be useful in that context, as they are with in other contexts as well. What other questions did we have? I think I covered most of them, Martin. I cannot hear you.
I have some others here that I could maybe, we already negotiated some extension of time, so we're lucky. Here's one from Ibrahim Razak. Thank you for the presentation. In a hypothetical situation, how do we settle a dispute between two indigenous tribes? claim ownership to particular TCE. I have another one from Audrey Williams. Well, thanks for your excellent presentation. What do you think about the registration of TK and TCE as a requirement for protection? Should it be optional or mandatory? There's another one, from Shinsuke Ishihara. Do you think a cultural expression should be protected forever, or rather should there be a term of protection for cultural expression? Another one interesting from Ezgi Oruk, sorry if I wrongly pronounced. Can we consider traditional recipes in this scope? Another one from Nadia Troncoso. Has international level protection been considered? Its inclusion in an international treaty? Oh, tough question.
Yes.
Do you want to go ahead with this?
Sure, I'm happy to. So yes, so thank you for all these additional great questions. And yeah, so the question, international level protection is being considered by WIPO member states, and they're in the process of negotiating an international legal instrument to protect traditional knowledge and traditional cultural expressions. So this is ongoing work. Now, on the term of protection, it's true to say that most IP rights are time limited, like copyright, patents, and trademarks. To some extent, we would say that they could have indefinite protection. And Indigenous peoples and local communities would like protection that is indefinite in time. And this clashes a little bit with intellectual property rights, which, the balance in the system that says that after a while, the works go in the public domain for everyone to use. So one way to think about that would be to say that perhaps there could be, and this is something that is being discussed in the context of the IGC by WIPO member states, but could be to say that perhaps there could be protection as long as the distinctive link between the community and the cultural expression is still existing, basically. So as long as this link, when this link is broken, that could be the end of the protection, and it could be broken because there are no more members of the community, they don't practice the specific cultural expressions anymore, and various types of reasons. But that could be one way to consider the term of protection. Now, registration, should it be optional or mandatory? Should it even be optional, or should there be registration even as an option? I think in most of the models that we're looking, they're not necessarily formalities to protection. But when there are, it would be important to see what really, what are the objectives of those formalities. Should it be something like models that we see for copyright registration in some countries that is not a requirement, but it's useful for a number of reasons. So, there are a number of discussions around that as well, going in both directions. And Ibrahim questions on disputes between communities. So that's a very good question, because it's a reality to say that different communities within the same region, perhaps, either they can be within different communities within one same country, or different communities within two separate countries actually can share traditional cultural expressions and claim interest in those traditional cultural expressions. and how do you resolve these kinds of conflicts? And that's a very good question. I imagine one good way would be to think about mediation, perhaps arbitration mediation within the communities. But yeah, it's a tricky question, that's for sure. Yeah, I think that covers.
Yeah. Okay, just the last one question, and there's a lot, but this is a very interesting one. Says from Leon Rivera, I think, what happens with countries that incorporates into their domestic legislation all the legal figures looking forward to protect their TC and TK, but cannot protect the TC and TK in foreign countries?
Yeah, so that's, I'm just reading the question as well in the chat. Yeah, and I think that's the moment where we say that it will be quite useful to see the outcome of the negotiations in the AGC to have the answer to these types of questions. But yeah, indeed, that's yeah, for these types of like situations that arise, we're hoping that the international legal instrument will have the answers to that.
Yeah, before close this, I just have a question. If there's any, just for the general information to the audience, how, if there is any, let's say, communication joint program with WIPO and Unesco on this topic, or each organization goes by their own way? Can you tell something about it?
Yes, of course. So, so UNESCO and WIPO both work on this area, this type of subject matter, so cultural heritage or traditional cultural expressions. And there would be overlap, obviously, on the subject matter, but we look at it from different angles. So from an IP perspective, we would be looking at how intellectual property can prevent the misappropriation and misuse of traditional cultural expressions, whereas UNESCO's angle would be the preservation and safeguarding of traditional cultural expressions, and both are important and complementary. So there are two pieces of the puzzle in a way. So we do work closely with UNESCO on a number of projects and areas, each with our own expertise, of course.
Oh, thank you, Daphne. Thank you very much for your interesting presentation. Again, many people are asking for your slides. I believe this is a very good beginning for this series of webinars. Again, I really appreciate Gwen, of course, Begonia, that has been wonderful. And we prepare for the next TC webinar with Karen Abraham, Pilar Toscoso, who are working on it. We have a very interesting format. And also please include your agenda again on June 7 with WIPO and AIPPI, a Genetic Resources webinar, June 29, and a second one in connection with Genetic Resources, and July 29 on TCEs. I really want to thank all of you, and again to Michelle and Cinzia for all the support, the patience, and we will look forward to see you again in another webinar of AIPPI and WIPO. Thank you all. Thank you, Daphne. Thank you, Gwen, Ralph. Thank you.
Thank you, Martin, and everyone. Such a pleasure to participate.
Thank you.